Brown, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Marshall Crawford. Welcome, everyone, to an oral argument session of the 6th District Court of Appeal. My name is Petra Brownlee. I'll be the presiding judge this morning. I am joined today by my colleagues, the Honorable Roger Gannum and the Honorable Jay Cohen. At first, we'd like to thank UCF Legal Studies for having us today and Dr. Lisa Norrid. We appreciate it, and it's our pleasure to be here this morning. We have 2 cases on our docket today. And before I call the first case, I'd like to ask each of the lawyers if they would stay after your respective arguments to answer some questions of the students, if you have time to do that. If you don't, we certainly understand. So we'll take a pause after each of the cases and let everyone ask some questions. All right. Our first case today is 24-1175. It's Peter Fleck and Carrie Fleck versus First American Title Insurance Company. You may approach the podium, and counsel for appellant, if you would please go ahead and tell us how much time you would like for rebuttal.
Good morning. Thank you.
Good morning.
I'd like to reserve 5 minutes for rebuttal.
Whenever you're ready, counsel.
Please the court. My name is James Powers, and I have the pleasure of representing Peter and Carrie Fleck, who are here with me today. We're pleased to be included in Law Day and seeing students from the UCF campus here. We're very happy to be here. On July 23rd, 1999, First American Title Insurance Company issued a residential title insurance policy to Peter and Carrie Fleck when they purchased their property on Lake Down in Windermere, which included a dock and an enclosed boathouse. On or around October 15th, 2018, Bradley and Sarah Geis acquired vacant property next to the Fleck's property, built a home, and became the Fleck's neighbors. The Geises complained that the Fleck's dock and boathouse structure was interfering with their riparian rights, and the Geises eventually filed a complaint against the Fleck's in circuit court on that basis. The Fleck's made an insurance claim with First American Title Insurance Company seeking insurance coverage, seeking a defense under the First American Title policy, again, asking for First American to come in and defend the Geises' complaint. After First American denied the Fleck's claim for insurance coverage, the Fleck's filed a complaint against First American, seeking a declaration from the trial court that the Fleck's are entitled to coverage under the terms of the title policy issued to the Fleck's by First American. First American filed a motion to dismiss, and the trial court entered its order granting First American's motion to dismiss the Fleck's complaint with prejudice.
Counsel, we're familiar with
Yes.
the procedure and the facts of the case. I think the students even have been given summaries. So why don't we get to the legal issues that are involved on appeal?
I was just about to do that. I was kind of setting the table for them in case I just didn't. Okay, appreciate that. Okay, so the case law that applies to this is really not in dispute. It's really the application of the 4 corners of the Geises' complaint to the policy language that we see in the First American policy. Okay, and under Florida law, just some general principles. The First American's duty to defend, the Geis action is determined solely by the 4 corners of the allegations set forth in the Geis complaint against the Fleck's. If the allegations of the complaint leave any doubt regarding the duty to defend, the question must be resolved in favor of the insured, requiring the insurer to defend.
And the Geis complaint alleged that the rebuilding of the dock expanded past the original footprint and then affects the riparian rights of the Geises, correct?
That is not correct, Judge. They included in their complaint allegations that there was an increase in the footprint. Okay, but the way the complaint is worded, and very familiar with it because I defended it.
I didn't suggest that the dock itself went onto the Geis property. I think the complaint indicates that it was within the Fleck property. But it's the riparian rights that are being claimed, correct?
That's true, but it's not, there is nothing in the guy's complaint that said, and this goes to their exclusion about creating the infringement of the riparian rights, okay? There is nothing in the Geis's complaint that clearly states that it's because of an increase in footprint that you have this infringement on their riparian rights.
Let's assume hypothetically that the dock was completely within their property. Let's assume hypothetically that they built up, that they redid this dock a couple times. And let's say hypothetically that they went up and put a top golf type structure where they hit golf balls into the lake and it goes up 50 feet. Is that violative of the Geis's riparian rights, and how would that be impacted? How would that impact the title? Because this policy protects against title defects.
Title risks, yes, risks. Okay, in your hypothetical, first of all, the trial court in this case had one issue really before it, and that is, does the flex dock structure and boathouse, okay, unreasonably interfere with the Geis's riparian rights? And that goes to ingress, egress, and view. That's really what they were focused on, okay?
But this is a motion to dismiss. We don't have any real evidence of how it impacted the Geis's. That would be done at the trial of this case.
Well, but you asked a hypothetical. If they built something way high, wouldn't that impair it? Well, maybe factually, the judge would find that, yeah, that building it up like that impairs their view and is a violation of their riparian rights. But nowhere in the Geis's complaint does it give dimensions of what the boathouse and dock structure, what those dimensions were at the time the Flex purchased their property in 1999, and First American agreed to insure the title risks associated with that property, which included
Did First American guarantee title? I mean, it seems to me that if we're looking at someone's riparian rights and the insurance company is guaranteeing this title, why would they be protecting the Geis's riparian rights as opposed to the Flex?
And they're not. Okay, this case is about whether or not the riparian rights of the Geis's, okay, were impaired by virtue of this dock existing, okay? And so what you have in the policy is it ensures structures,
But
okay?
if the policy doesn't protect the Geis's riparian rights, why is there a duty to defend?
That because of title risk number 12, where I can read directly from it. And again, we're talking about risk. In 1999, I recognize my burden here. In 1999, when First American issued this title policy, okay, they were insuring risks that were present at that time. Not what occurred in the future, it was what was present at that time. And the Flex purchased a dock and boathouse at that time. And so the way Florida law is set up is that in order to determine whether there's an impairment of riparian rights, okay, you have to have a court of competent jurisdiction determine that, okay?
So if we just freeze frame right now and we say you're protecting riparian rights, is it your argument that it's everyone's riparian rights that the Flex could arguably be affecting, or is it the Flex?
Okay, so what we do is we go to covered title risk 12,
Yep.
which says the policy covers the following title risks, okay? If they affect your title on the policy date. So we're talking about how they could find themselves in an action where, and we look under 12, and I quote, "You are forced to remove your existing structure other than a boundary wall or fence because it violates a restriction shown in Schedule B."
Mr. Powers, I want to spend some time on the word restriction there, because
Yes.
in this form, title insurance policy, anyone who deals with these types of land sale contracts and title insurance policies knows you have exclusions, you have exceptions, and you have conditions. And so this title risk number 12 talks about it violates a restriction shown in Schedule B. and Schedule B is exceptions. So what does the word restriction mean in this provision?
Well, this is a great question because this is what got my attention. I've done coverage work for a long time, and it's very peculiar that you have the insuring provision, in this case, the so-called covered title list, which says here, we're going to cover this loss where you're forced to remove an existing structure, that is the dock and boathouse, okay? And that's what the Geises are seeking in their lawsuit, is the removal of this dock and boathouse, okay? So we have an insuring provision that then says, because it violates a restriction shown in Schedule B, and Schedule B is a whole list of exceptions. I mean, when you go to Schedule B, it begins, this policy does not insure against loss or damage, et cetera, et cetera.
And
So
will
you have the
grant you-
peculiarity of an exception being included in a coverage provision.
And I would grant you that I think the insuring provision in number 12, it creates an exception to an exception.
Exactly.
I get that. Schedule B lists out your exceptions.
Exactly.
And item 12 refers to a restriction shown in that list of exceptions. So my question is, what does restriction actually mean? Is it a restriction in coverage, which seems to be the thrust of your briefing, or is it a restriction on the flex rights to do what they want on their property?
I think it's referencing that which is stated within Schedule B as an exception to the exception, and you look at number 8, and what do we see there? Riparian rights.
But don't we have to look at the items in the list of exceptions for what they are? For example, I mean, number 8 is peculiar because in the exceptions, it begins, as you said, this policy does not insure against, and then loss or damage which arise by reason of, colon, and then you have all these listed exceptions. But when you get to number 8, it's a standalone sentence. It says riparian rights, rights of accretion, reliction, submerged lands, or any other water rights of any nature whatsoever are neither guaranteed nor insured under the terms hereof as to lake down. It doesn't quite fit with the rest of them that all sort of correspond to that opening language on the list of exceptions. And so when I look at that, I mean, is it really good enough just to say, well, if I can find the word riparian rights on Schedule B, then that means the insuring provision covers that? Or do we have to look at these exceptions for what they are and say, well, whose riparian rights are not guaranteed or insured under this policy?
Well, I think that it's saying in a hypothetical outside of what we have here, that let's say that there was the flex title, they sell it to somebody and they're saying, well, look, we don't have upland property here. So riparian rights attached to upland property. And so this is a defect in your title here. You come in and ask for coverage, and First American would properly be able to say, no, that's not something that we're going to insure because we're telling you that we're not insuring your riparian rights. But when you take a coverage provision, covered title risk 12, and you say, here are the risks that we're going to cover, and you incorporate exceptions into it, and you don't state which are restrictions. Any limitation is a restriction. I mean, that's basic definition, and the policy even begins, your insurance is limited, using the word limited, by exceptions in Schedule B.
So is it your argument that the word restriction in the insuring provision number 12 is synonymous with the word exception?
I think it is. And because it's referring to Schedule B. And Schedule B is titled exceptions from coverage.
So
And it
Florida,
doesn't delineate, it doesn't define which are, if they don't define which are restrictions and which are something else.
the Florida Supreme Court has validated many canons of construction. One of them is the presumption of consistent usage. So if we look in a written instrument and we see the word exceptions used over here and the word restriction used over here, the presumption is they mean something different. Don't we have to look for some other meaning to the word restriction or else violate that basic canon of construction?
I think that's fair to say, but I think that it still so fits the circumstances here, where you have a lawsuit brought to ask for the forced removal of existing structures, and the flex dock and boathouse existed in 1999 when they issued this policy. And, you know, the way the complaint is worded, you know, you have in paragraph 60 of the complaint that the Geis has brought, it says, in light of the defendant's refusal to remove that portion of the dock mooring area on the Fleck property which violates plaintiff's riparian rights, the court, they seek a declaration that the dock needs to be removed. I mean, it matches up so directly with this, with coverage title.
Counsel, if we don't think that they are taught that this policy is referencing the Geis's riparian rights, but instead is ensuring any riparian rights that the Flex would have and their title and how it might be affected by an impairment to their riparian rights, if we think it's about the Flex and not about the Geis's, can you still prevail? Was there an argument made to the trial court through which you can prevail on this policy and demonstrate coverage?
You know, what I would say is that it's about their structures. This lawsuit is seeking the removal of structures, and it's structures that the policy is insuring. What it's doing is it's saying under what circumstances are we going to insure those structures? And it goes to say that where, you know, it's the forced removal, which is what they're seeking in the trial court, the forced removal because it violates something shown in Schedule B, a restriction.
The transcript of the hearing in this case reflected that the trial of the underlying issue occurred 1 week before the hearing on the motion to dismiss, and experience would tell us that that has been resolved by this point in time. So hypothetically, if your clients prevailed below, is what we're talking about here attorney's fees?
Yes.
Counsel, you're
And
into your
provided that they, I mean, it has concluded, it's actually up on appeal. It's, you know, provided that it doesn't get sent back or something. But yeah, right now we're talking about attorney's fees.
So provided that it doesn't get sent back, tells us that your clients prevailed below.
My clients
Who filed the appeal?
the Geises.
You're into your rebuttal time, counsel.
Okay, appreciate your time.
May it please the court, Your Honors, Maya Hatchett on behalf of First American Title Insurance Company. I'm going to jump right into the issues just in regards to what was just stated as to about the structures. The circuit court properly dismissed this complaint based upon the structures because the title policy does not insure the dock, which is not a part of the property that is insured under the policy, which is specifically Exhibit A.
So on Schedule A of the policy, how can you tell that, Ms. Hatchett? How can you tell on Schedule A whether or not that dock is included in it? What paragraph would you point us to?
I would cite to the exhibit, Your Honor, as to Exhibit D to the Geis's complaint, the survey, which maps out the property boundaries of the properties and shows that the property boundary and where the dock is located is outside.
But can we look at that? I mean, the policy tells us to look at Schedule A.
For the purposes of the complaint, which is alleging that coverage is, the complaint of the Geis's is incorporated into the flex action, and therefore we're entitled to look into the exhibits of the complaint.
I think you can look into the exhibits, but as far as coverage is concerned, doesn't the policy tell us that the property's outlined on Schedule A, and then I look at Schedule A and I see the 3 paragraphs? But you're asking me to go outside of that?
I don't believe it's going outside of it, Your Honor, in that it's the title policy is very specific as to it being only Exhibit A. To determine whether or not Exhibit A, what Exhibit A is, you are entitled to, I think, in any situation where you're dealing with determining what is in Exhibit A.
How could we possibly look to the Geis complaint to determine coverage under a title insurance policy? The Geis complaint is years later. This policy is issued many years before that complaint. We don't look to the Geist complaint to determine whether that dock is covered under the title insurance policy. That makes no sense.
Well, I think from the purposes of duty to defend, you'd have to look at the Geist complaint as to whether it's a duty to defend. But as to the policy itself, the policy and what is covered under the policy is exactly in policy. I agree with that in that it specifically states in the first paragraph that it ensures title to the land described in Exhibit A. It goes on to state that in the covered title risks, that the policy covers the following risks that affect your title on the policy date.
Can I ask you about this word, this combination of words here? Because, for example, land is defined in policy to mean what's shown on Schedule A. Title is defined as the flex ownership interest in the land. But the insuring provision says it covers the following title risks if they affect your ownership interest in the land on the policy date. Don't riparian rights affect the ownership interest in the land? I mean, the case law says they inure to the benefit of the land owner. And so anything that challenges or touches on riparian rights certainly would affect their ownership interest in the land, even if the dock, for example, is not on the land itself.
If we were dealing with the riparian rights of the flex, I would agree that the title policy would be at issue. But we are only dealing with the riparian rights of the Geises. That is not ever covered under the title policy of the flex.
Are we really dealing with the Geis's riparian rights? I mean, if the dock is, and maybe it's different because it's the dock, so that's part of my question, right? But are we maybe also looking at the flex's riparian rights if the dock is out there? And so if you're looking at something that's, in the water, does that help the other side at all, or why not?
I don't believe that is at all what is at issue, not only from the complaint that was brought against First American by the flex, where it makes it very clear the issue is the riparian rights of the Geises, but the Geises complaint itself. It's a violation of the Geises riparian rights.
Can you tell me do you know off the top of your head what it is in that complaint that you're referring to that demonstrates clearly that it's the Geises riparian rights that are alleged to have been violated? I think I agree with you. It's a sticking point for me, so to speak.
Paragraph 11 of the flex complaint, it states that the Geises complaint is pending a riparian action, alleges in pertinent part that the Fleck Dock Boathouse extends from the Fleck property into Lake Down, into the Geises riparian area.
Okay, and that's in the flex complaint, not the Geis complaint, but it's coming from that.
That is from the flex complaint. I
Okay.
can also state there's multiple references
Okay.
in the Geises complaint as to their riparian rights being violated.
Thank you, counsel.
Ms. Hatchett, I want to ask you the same question I asked Mr. Powers. How would you define the word restriction as shown in the insuring provision, number 12?
I believe that a restriction is different than exclusion. It's different than an exception. A restriction is something that restricts an owner or an insurer's ability to use their property.
Okay, and so if that's a definition, then if we go to Schedule B and we look at the exceptions here, and we look at number 8, that refers to the riparian rights, let's assume it's the riparian rights of the flex. Number 8 is telling the flex, we aren't going to guarantee or insure your riparian rights in this policy. But by mentioning the flex riparian rights, doesn't that infer that some boundary to those rights such that they can't exceed their riparian rights? In other words, isn't there a restriction sort of inherent in a provision talking about the flex riparian rights that would be enough to trigger the insuring provision in number 12?
I respectfully disagree. I think at paragraph 8 makes it very clear that it's dealing with the rights of the riparian rights, and it specifically states that it does not guarantee or insure them. And because it's not a guarantee or insurance that you will have them, it is strictly a right.
And so you would distinguish that from some other item in the list of exceptions, for example, a boundary agreement or something that may restrict the flex, what they can do on their property.
And exactly, or a declaration. A declaration is oftentimes put in a Schedule B that has many different restrictions on what can and not be done on your property or to your home. And those would be, if you were forced to remove something or change something with your property due to a declaration, that would be something that would be covered by paragraph 12.
Counsel, it seems to me that your argument with regard to riparian rights as listed on Schedule B, it's almost like it just asks us to look at the language on Schedule B rather than the policy as a whole. So if you're saying that and I grant you this, that the policy states very clearly the policy does not insure against loss or damage which arise by reason of, and then you've got the riparian rights listed in paragraph 8. But what are we to do, because this is the language that opposing counsel really grabs onto, and that is the covered title risks. And it's the policy covers the following risks if they affect your title on the policy date. And then we go to 12, you are forced to remove your existing structure other than a boundary wall because it violates a restriction shown on Schedule B. So don't we go from there right to paragraph 8? What are you to do with that language? I know your position with regard to the language at the top of Schedule B about the policy not insuring these items. But what's your response to, this language of paragraph 12?
Paragraph 12 expressly states that you are forced to remove your existing structures. Existing would be at the time that the policy was made. The word existing has to be given meaning. And respectfully, although counsel states that the Geist complaint does not state that the current dock as of 2021 was a different dock than what was in 1999, the complaint is very clear that it is. And I specifically
I'm trying to wrap my arms around that argument. So let's say that I own a dock and I rebuild the identical dock because in time it's in water and it rots out. And so I rebuild the identical dock. Are you suggesting that because I rebuilt a dock that didn't exist at the time of the policy, is that your argument?
Yes, Your Honor, that the argument that it would not be there, but that is not the facts that we have before the court today.
That's the argument you just made to this court, that it wasn't in existence at the time of the issuance of the policy. And I find that hard to swallow, that if I rebuilt a dock identical in footprint to the original dock, that it's not covered because it wasn't in existence at the time of the issuance of the policy.
I think that is an argument that can be made as to coverage, but is not an argument that can be made in this case where it is very clear that the dock was...
That's the argument you just made.
The dock, no, I'm making the argument that in these current circumstances, the dock in 2002 was completely redone and is expressly stated the footprint of the new dock constructed in 2002 extended beyond the footprint of the original dock.
In your brief, you suggested that it wasn't in existence and it didn't seem to restrict it to the fact that the footprint extended beyond the original footprint.
My position is that in these circumstances where the dock clearly expressly states that it's a new dock that extended beyond the footprint, it is not covered under the flex title policy.
If they rebuilt that dock to its original footprint or within the original footprint, is it covered?
I do not believe, I think we have to go back to the express law of the Supreme Court of Florida, that a policy is with clear and unambiguous language. It expressly states that we have to put terms to each part of the contract. It says an existing structure. That is not an existing structure.
Ms. Hatchett, what about a situation where, I'm going to give a hypothetical, but I'll use the same party's names just for convenience. Suppose that when the Flex bought their property, there was a guest house on it that crossed the property line into the property that the Geisses eventually purchased. And the Geisses wanted to enforce their property line, and so they sue the Flex and say, your house, your guest house is encroaching our property line. But that complaint alleges that the guest house was built 10 years after the Flex bought their property. Incorrectly, but that's just what the complaint alleges. It alleges that it was a newly built guest house that crossed the line. And the Flex go to their insurance company and say, they're suing me to remove this structure that crosses their property line. But this house was here, this guest house was here when we got the title policy. Their allegation that we built it later is just incorrect. Are you saying that the allegations of the Geisses complaint and that hypothetical would mean that there is no duty to defend because we have to look only at the allegations of the complaint? Or can the insurance company, or do they have to listen to their insured saying that that's a mistake, that's actually not true?
For different purposes, for the duty to defend, the limitation is to look at the Geis's complaint. But as to coverage under the policy, it can go beyond that.
So in that situation that I described, wouldn't the way for the flex to obtain coverage would be to sue their insurance company and say, you need to provide me coverage because what they're alleging is incorrect. This is actually a structure that was existing when we bought our property.
That's not what they have done here. And the complaint that they allege against First American is that they have expressly stated that the Geises have brought allegations of Geis's riparian rights that they want First American to defend against. In your circumstances of a boundary line, where it is an argument that the structure was there existing at the time of the policy and was on the property, that would be a covered claim that would at least have a duty to defend.
But would that duty to defend arise even if the complaint incorrectly alleged that it wasn't an existing structure at the time the policy was issued? In other words, can the insurance company say, sorry, what they alleged, exactly what they have alleged isn't covered, so we're going to sit back, let you defend it, and then if you prove later on that it was covered, then we'll come in and pay then?
Yes, in regards to the duty to defend, it is expressly must be looked at as to the claim, what has been claimed against the insured. And that is the complaint, and the law is cited in my brief.
I want to switch gears then, and I'm sure you're aware that the case law is favorable towards the insureds in many ways when you have an insurance policy. If it is an inconsistency in the policy, it's resolved for the insured. If it's an ambiguity, it's resolved for the insured. And the cases also say if there's any question of the duty to defend, it's resolved in favor of the insured. So my question is, can you point to the Geis's complaint and say, unequivocally, it's talking about a dock that was not existing at the time the policy was issued?
It goes into, in paragraph 11, it goes into alleging and incorporating the Geis's complaint. And as I already stated on record as to the allegations of it being about that the dock extends from the Fleck property into Lake Down, into the Geis's riparian rights. Based upon that allegation, it is not covered because it is not part of the property.
But what if, I'm just talking about the existing structure part of it, because I believe you've argued that this dock was, as it exists at the time the Geises sued the Flecks, was not the same dock that was there when the policy was issued. And so when I read the allegations of the Geises complaint, I see references to reconstruction, rebuild. It was mostly replaced. What I don't see is an allegation that says the old dock was completely removed and a brand new dock was constructed in its place. And so I guess short of that, is the motion to dismiss stage the time for the trial court to resolve as a matter of law that once you reach some portion of rebuilding or reconstruction, it's no longer the existing dock? Or does that have to be developed factually after the motion to dismiss stage?
I think it is proper on a motion to dismiss in these circumstances. On the duty to defend, you are limited to looking at the Geis's complaint, and it is very clear from the Geis's complaint that the structure, the dock was not existing and actually had been completely rebuilt, not only once but twice in these circumstances. As to the coverage, it also is clear and proper on a motion to dismiss that there is no coverage under the policy based upon the dock not being within the property insured, and specifically I refer to the policy and to the definitions. Title is defined under the policy as the ownership of your interest in the land.
Do I
That is not-
understand your brief properly, correctly, that the Flecks have to wait until there's an order to remove the dock before coverage exists?
There is no coverage, there's no duty to defend under the
That's
Geis's.
kind of a yes or no answer. Is that the argument
No.
that you made?
The duty to defend is shown by the Geis's complaint. There is still no coverage under the policy even after that fact because the riparian rights of the Geises are not a title of risk that is covered under the policy. We've touched and talked extensively as to the flex claim is not for the title to the insured property. I think we've also touched on the fact that the title policy is also clear that the flex claim is not covered because it does not present a risk that affects the flex property on the date of the policy. And I recited the language that is very clear. I said, as to paragraph 26 of the Geis's complaint that shows that there was a new dock, and also as to paragraph 34 of the Geis's complaint that makes it very clear that
What makes it a new dock is the extension, not the fact that it was rebuilt. Is that your argument?
pursuant to the exact language of the Geis's complaint, the footprint of the 2020 dock rebuild extended well beyond the footprint of the original dock and added more doors to the southern portion of the dock that, when left open, which occasionally occurs for long periods of time, extend even further beyond the original footprint of the dock.
It should have been farther.
And there's a floodlight, right?
Yes, Your Honor, there is a floodlight.
Ms. Hatchett, in this existing structure question, I guess, I understand your argument that wherever we would draw the line between, when a structure stops being an existing structure and becomes a new structure, wherever we would draw that line, your argument is that we're way beyond it. But what is the line? How much of a dock, for example, has to be replaced or rebuilt before it stops being the existing dock and becomes a new dock?
I've had cases where there has been a dock where the pilings and everything has remained in place. And what only was replaced was the top boards, the repair was done to the top boards of the dock. I believe that would still be the existing dock. So when it is considered a repair and not changing the footprint of the dock, I think that it would be covered under the policy.
And do the factual allegations in the Geis's complaint against the Flex tell us whether pilings were removed, whether the boards were changed? Does it tell us how much of that dock was changed? Other than to say things like rebuilt, reconstructed, mostly changed.
I think it goes into detail, Your Honor, as to expressly stating that the footprint of the new dock was extended beyond. It also says the footprint extended well beyond the footprint. It goes into what it was done. It added doors to the southern portion of the dock. It also states that even farther beyond the original footprint of the dock, that they added a mooring area to the west of the dock, which mooring area further extends and trespasses on the riparian rights, and that's paragraph 34 of the complaint.
And if your clients come to you and say, that's not true, that's got no impact upon coverage and duty to defend,
then they're going against the controlling law of the state of Florida, where the Geis's complaint will control the duty to defend.
Thank you, counsel.
Your Honor, in conclusion, what is presented in the law that has been presented today, along with the facts, clearly show that the circuit court properly found that there was no duty to defend and no coverage under the policy. I respectfully ask that the decision be affirmed.
Counsel, you have 4 minutes and 7 seconds left in your rebuttal time.
Okay, I want to make a point about a couple things. First of all, we've been examining the nuances of restriction, existing, and parsing it out, and trying to apply. And I think
that's what we do.
And that's what we do, but I think when it comes to looking at an insurance policy and the rules that are in place that favor an insured, such as any doubts or ambiguities are construed in favor of the insured, in favor of my clients, when we're parsing, okay, you might find that what counsel argued is a reasonable interpretation of restriction, and I think you should find that what I argued is a reasonable interpretation. You have two reasonable interpretations. You are forced at this stage to be adopting that which favors my clients, the Flex, to find coverage. And I think that that's kind of sprinkled throughout this case.
Counsel, what are we to do with the fact that in the policy, paragraph, 3 of the exclusions says title risks, and it says, in addition to the exceptions in Schedule B, You are not insured against loss, costs, attorney's fees, expenses resulting from title risks that are created, allowed, or agreed by you. If indeed the Geis's complaint talks about adding this mooring and changing the footprint of the dock, and that by virtue of that, they have affected the Geis's riparian rights, why aren't you all kicked out by paragraph 3?
Okay, so I spent some time in the briefs on this and other places. The complaint alleges a lot of things, okay? What it had to do, what the Geis's complaint had to do was state a cause of action. And its cause of action was stated by virtue of saying that the Geis's have property adjacent to the flex, and that it's been adversely affected by the existence of this dock, and the court is being asked to say, remove the dock because it violates our
Remove a portion of the dock.
well, whatever portion. I mean, there's nothing, the complaint is very ambiguous as to what it's saying should be removed. They're saying all or portions, they say different things in there. But the point is that the Geis's complaint stated a cause of action because they alleged there was an infringement of their riparian rights due to this dock. Now, they added a bunch of things about increasing footprint. They added things about not complying with this and that. That was done to try to bolster up their case to say, well, if they didn't comply with the EP, then that would be a reason for invalidating the dock, and therefore, it'd be another reason to get rid of it. But the complaint, when you look at the complaint in its essence, it's about whether there was a violation of the riparian rights because of egress, ingress, and use.
The Geis's riparian rights.
Correct. Okay. Yeah, that's clearly stated in their complaint. But the language in there about increasing the footprint is not necessary to state a cause of action, okay? A feature of the trial, but not necessary to prove in order to still have the court potentially find a violation of the riparian rights because of the existence of this dock and boathouse, which existed in 1999. So the created exclusion, the created language is in the exclusion. You can't make that determination at the motion to dismiss stage. I mean, how things might play out in the course of that trial, okay, maybe that's where it goes to. But it didn't have to go to any finding of an increase in footprint in order for the Geis's to get the relief they were seeking. It simply had to be demonstrated.
But we're just talking about the duty to defend, right? And so wouldn't we look to the four corners of the complaint, of the Geis's complaint, in order to discern whether the insurance company has that obligation? And if it very clearly alleges, something that immediately puts the insurance company outside the scope of its duty to defend, can't that be decided on the motion to dismiss stage?
Okay, the principle at work here is another principle in insurance law, which states if the complaint alleges facts partially within and partially outside the coverage of the policy, the insurer is obligated to defend the entire suit. And that's what I'm arguing here. They had an obligation to defend the entire suit, even though some of those allegations maybe would trigger an exclusion at some point in time, depending on how things shook out. But the bottom line here is I believe that the flex are entitled to coverage. They're entitled to at least a duty to defend as set forth in the law applied and the policy language. And I'm seeking this from this court, an order reversing the trial court's decision to dismiss the flex complaint with prejudice. Thank you.